The Constitution begins with securing justice. Doesn't start even with the general welfare or the common defense. But access to justice is only meaningful if we can make lawyers available irrespective of somebody's ability to pay.
Any telling of the story of civil legal aid has to begin with that fundamental American promise of justice for all, not just for the few who can afford it.
My name is Hazel Faluxian. I'm a former farm worker. I worked in the fields and groves and lived on the labor camps in parts of the United States for 40 plus years. The life we lived as a farm worker on those labor camps, you were scared to even go outside alone, not even to mention walk alone. They were snatching people up, putting them in their vans. They were buying people $65 a piece. I witnessed it.
People are not familiar with the laws, and they certainly don't realize what they need to do in order to protect their rights.
And yet in the civil justice system, people can lose their homes, they can lose their families, they can lose their livelihoods. What we find today in civil courts is that 3 out of 4 people are there without legal help to navigate the system.
Although access to legal representation for serious criminal crimes is guaranteed, regardless of the defendant's ability to pay for an attorney, no such right exists in civil courts. Solutions to provide legal assistance to vulnerable people develop over the course of nearly a century, and the fight is not over.
Legal aid addresses the most fundamental issues of any society and the most basic of human needs. Legal aid is about families and family stability. It's about child custody and child support and adoptions and guardianships. Legal aid is about personal safety, protection against abuse and violence. Legal aid is about the roof over your head, shelter, protection from evictions and foreclosures. Legal aid is about health and food and subsistence. But legal aid is about more than just corporal needs. It's about respecting human dignity.
Lawyers, I think, do pro bono for a wide variety of reasons. And probably the most important is because people feel that it's an ethical responsibility. There isn't a law or a rule of conduct that requires lawyers to do pro bono, but if you get a law license, you really ought to be using it, at least in small part, to help folks who can't afford to hire you.
The instinct of lawyers to help the poor is not a new one. By the late 19th century, lawyers were beginning to organize their efforts. The Freedmen's Bureau was launched by the U.S. Department of War to help freed slaves during the Reconstruction period after the Civil War. One service the Freedmen's Bureau provided was free advice from lawyers. When the Reconstruction period ended in 1872, so did the Freedmen's Bureau. Sustained efforts to provide civil legal assistance for poor people in the United States began with the German Immigrant Society in New York City.
The first program in the United States to have a staff lawyer representing poor people exclusively was the German Legal Aid Society. In 1889, it expanded to 4 offices and served not just Germans, but all ethnicities of poor people. And it continues to the current day as the Legal Aid Society of New York some 144 years later.
The legal aid delivery model was to enlist lawyers in private practice to provide free services to clients who could not afford to pay. In addition to this approach, what is now called pro bono work. The society employed staff lawyers to directly serve poor clients. In 1911, 15 legal aid programs formed their own association, now known as the National Legal Aid and Defenders Association. The organization's mission, then as today, was simple: fulfilling the American promise of equal justice under the law. Early in the 20th century, a legal aid leader captured the public's attention. In 1919, Reginald Heber Smith, director of the Boston Legal Aid Society, became so appalled by how the poor were treated in the courts that he wrote a book exposing the problem. His book, Justice and the Poor, moved the national conversation on the plight of the poor in civil courts. That book convinced former Republican presidential candidate Charles Evans Hughes to make legal aid the centerpiece of the 1920 meeting of the American Bar Association.
It was so influential with that American Bar Association then at that meeting that they, at that meeting, created a new committee called the Special Committee on Legal Aid Work with Charles Evans Hughes as its first chair. That started a national movement of trying to expand legal aid across the country.
Between 1920 and 1930, 30 new legal aid organizations were created. Yet it has been estimated that during its early years, legal aid reached less than 1% of those in need. Legal aid societies have always hired some full-time staff lawyers, but their capacity was limited by dependence on charity for funding. During the 1950s, 60s, and 70s, the legal profession began a period of unprecedented growth, expanding with the post-war U.S. economy. This growth also fueled substantial increases in pro bono work in large law firms.
And in some ways, that's been great for pro bono. It's brought in more warm bodies to do the work. It's enabled the firms to set aside some money for pro bono counsel to support those who are doing pro bono. The rise of the target billable hour that large law firms typically have has been really challenging for pro bono service providers.
Well, pro bono lawyers are most helpful in partnership with legal services lawyers. They don't have the expertise in most of the areas of the law concerned to poor people, and so they need to have that partnership to make it work.
For pro bono work to be effective, there has got to be a strong infrastructure.
We are a legal triage room. We try to sort out those people who don't need legal help, those who can help themselves through information and advice, those that need emergency attention by one of our skilled lawyers, those who may need a lawyer but can wait for a pro bono lawyer to represent them. We triage those clients with scarce resources and do the very best we can to make access to justice a reality.
People want to make a difference. And I think for lawyers, it's very meaningful to be able to use your own skills, these skills that you particularly have, in order to help someone in a way that a person who doesn't have a law degree couldn't help.
We have a sense of compassion and desire to help community that is strong. We've seen over many generations of lawyers in America a willingness to represent people regardless of whether they have the money to pay. Today, that spirit is as strong as it's ever been, and I would say stronger.
After the New Deal and the victory in World War II, leaders turned to new ways of addressing social problems. Despite the growth of legal aid societies, their services were charitably funded, able to provide the equivalent of only 400 full-time lawyers to represent more than 37 million low-income people in this country. The combined budgets of all civil legal aid societies in the country totaled $5.5 million. In 1962, that was 0.1% of what the U.S. population spent on lawyers' services.
The civil rights movement was really the impetus for seeing that we had a long way to go to reach certain American ideals that we claimed to aspire to, but we weren't meeting.
Mistake.
After the assassination of John Kennedy, President Lyndon Johnson conceived a new role for the federal government: to end poverty. On August 20th, 1964, President Johnson signed the War on Poverty legislation, and after a few weeks later, named Sergeant Shriver to lead the effort.
For the first time in the history of this country, poor people actually have a place and a way in which to express themselves.
Although it was not part of the original War on Poverty legislation, the idea of a legal services program to fight poverty began after Sergeant Shriver read a seminal paper by Jean and Edgar Kahn entitled "The War on Poverty, A Civilian Perspective."
He was so struck by it that he called them immediately and told them to be in his office the next morning. And before the end of the week, Edgar Kahn was his speechwriter and special assistant, and Jean Kahn was a consultant charged with developing a legal services program.
Shriver realized that to succeed, the legal services program needed the support of the American Bar Association. He found an ally in Lewis Powell, the ABA president and future Supreme Court justice. Soon they passed legislation adding legal services to the government's War on Poverty. For the first time in American history, funding legal services for the poor in civil cases became a governmental responsibility. In its first year, 1966, the Office of Economic Opportunity quadrupled the nation's investment in legal services for the poor. By 1968, the investment had been increased eightfold from the era of private charitable funding.
The fact is, we're doing things, and we're affecting people who have never been affected before. We're giving a voice to people who have never been heard before. When that happens, that means action, that means controversy, that means excitement, and that means criticism, and that means all those things. But why get discouraged? In fact, I think it's encouraging.
The mission and the Times led the OEO lawyers to work closely with the civil rights movement. Then, as now, legal services lawyers representing disadvantaged people confront the racial injustice that compounds the burden of poverty for too many Americans.
Sergeant Shriver was obviously one of the heroes of the civil legal aid movement, and his commitment to it really had to do with his commitment to eliminate poverty in America. He was a warrior for that cause to the end, and civil legal aid he saw as a necessary piece of that effort.
The plan for federally funded legal services in the United States used staff attorneys working for private nonprofit entities. At the time, some advocated funding for what was called Judicare, a delivery system in which private practice attorneys are paid on a fee-for-service basis, similar to the way doctors are paid for handling Medicare patients. Clint Bamberger, the program's first director, felt that a nationwide Judicare system would be prohibitively expensive and would not provide the advocacy required to represent the low-income community. This fundamental policy decision has shaped the civil legal aid program to this day. In 1967, OEO Legal Services' second director, Earl Johnson, made another fundamental policy decision. Johnson wanted to create a cadre of young leaders to promote high-quality legal services. To achieve this goal, OEO funded the Reginald Heber Smith Fellowship Program to attract promising law graduates and young lawyers. The program provided a summer of intensive training and then placed the Reggies, as they were called, in legal services programs throughout the country for 1 or 2 year tours of duty.
In 1970, there were 1,500 applicants for that program, which represented 10% of the law students in the country applied to be Reggies.
By the time President Reagan closed the program down in 1983, 2,300 Reggies graduated from the program. About 25% of the lawyers working as legal services attorneys were Reggies. Springing out of their direct legal services work, some Reggies were able to make progress in passing anti-poverty legislation. For example, Alan Hausman, who would serve as executive director of the Center for Law and Social Policy, played a key role in advancing legislation about food stamp reform, nutrition programs for women and children, and supplemental security income. Also impressive was the rate of success in the courts achieved by legal services attorneys during this time.
In the entire history of legal aid from 1876 to 1965, there had only been one case in which a legal aid lawyer had argued before the U.S. Supreme Court. In the 7 years from 1967 to 1974, there were 110 cases argued before the Supreme Court by legal services lawyers, and they were successful in 64% of those cases.
Despite dramatic increases in service and success in the courts, legal services faced severe opposition in the realm of politics. In 1967, at the request of Governor Ronald Reagan, Senator George Murphy, a Republican from California, attempted to amend the Economic Opportunity Act to prohibit legal services lawyers from bringing actions against federal, state, or local government agencies. Had the effort succeeded, it would have meant poor clients would not have access to legal protections available to other citizens. Reagan had lasting antipathy toward CRLA, California Rural Legal Assistance, which aggressively asserted the legal rights of farm laborers. In 1970, Reagan sought to veto the CRLA grant based on a California government report that alleged 150 charges of misconduct by CRLA.
There was a commission put together of 3 Supreme Court justices from outside of California. And at the end of that process, they found that CRLA's advocacy had been competent, had been efficient and exemplary, and they cleared us of the 165 or so charges, and our funding was restored.
Reagan's opposition to legal services would follow him into the presidency years later. But he was not the first president to try to rein in federal support for legal services to the poor. In January 1973, President Nixon proposed dismantling OEO. He appointed Howard Phillips as the acting director to head the effort. Phillips, a vocal critic of the war on poverty, was determined to destroy the legal services program. To better protect legal services from politics, a Bar Association study committee recommended the creation of a private, nonprofit corporation separate from the federal government to receive funds appropriated by Congress and distribute them to local legal services programs. Although President Richard Nixon vetoed the original bill to create the Legal Services Corporation, he signed a revised bill into law shortly before resigning in August 1974 because of the Watergate scandal. The LSC Act created a private nonprofit corporation controlled by an independent bipartisan board appointed by the president and confirmed by the Senate. No more than 6 of the board's 11 members could come from the same political party. Since its creation, the corporation developed a minimum access plan to provide a level of federal funding for every area of the country.
The Legal Services Corporation is the country's largest funder of civil legal aid for low-income people. We support 132 legal aid programs with more than 850 offices serving every county in every state, the territories, and the District of Columbia. We are the backbone of legal aid in the United States.
After years of growth in the late 1970s, the Reagan administration was openly hostile to the legal services program. Reagan initially sought LSC's complete elimination and proposed to replace it with law student clinical programs and a Judicare system funded through block grants.
Those first 3 years of the Reagan presidency, you saw, I think, a closure of 300 legal aid offices throughout the country. 20% were closed.
Despite the political turmoil, it was the stories of transformation that won the day. Farm worker Hazel Faluxian's shocking account of abuse of farm laborers provided powerful testimony of the role of legal services in fighting for people who cannot fight for themselves. Her story begins when she went to a new camp.
When I got on this camp, I found out a week later that I was not allowed to work, that single women were kept as prizes for the male earning the most money that week. And I found that out the hard way because this person that earned the most money that week was a man about 6'6", old, maybe 225, and I heard the contractor ask him, "Which one do you want, mule?" He said, "I want the one with the green eyes." And I'm looking around the room praying to God that there is somebody else in there with green eyes. He came over to me and he said, let's go. I'm not going anywhere with you, buddy. And the contractor that was over the camp, she said, oh yes, you have got to go with him. I promised him. I said, you made the promise, you go with him.
Hazel managed to fight off the man, creating enough of a distraction that she would be able to escape the camp by climbing out of a window. Later, she contacted the Department of Labor.
A representative came out along with a legal service attorney. And I explained what was expected of me and that I refused. They took me to another place, and about 2 days afterward, the camp was shut down. They found so much going on in that camp that it was literally get these people someplace else to stay and cease and desist. And now a lot of those contractors are in prison. One doing time for slavery. Years back, that's what his charge was. Slavery, can you imagine? The fact now that the work and those overseeing your work is much better is because the Department of Labor and the Legal Service Corporation, they work hand in hand to help stop the labor violations and protect the workers.
Hazel went on to become an activist for farm worker rights and served as an advisor for Senator Edward Kennedy on farm labor issues. In 1991, she told her story before a congressional committee. James Ramstad, then a Republican congressman from Minnesota, attended the hearing that day and heard Hazel's testimony. He went on to actively promote legal services funding.
Mr. Chairman, as a member of the Administrative Law Subcommittee, I rise to offer my support to reauthorize funding for the Legal Services Corporation.
This growing bipartisan consensus around continuing funding legal services allowed the program to weather another round of political controversy in the mid-90s.
In the 1990s, during the Clinton administration, I was executive vice president of the Legal Services Corporation and then president on an interim basis for a total of about 4 years. That was a very consequential 4 years. It was a time when we, in some ways, resolved the very serious political debate that had been going on since the election of Ronald Reagan to determine what the federal role should be in provision of civil legal aid.
Seeking to limit the role of the federally funded legal services, the congressional majority passed funding restrictions to prohibit LSC programs from bringing class actions and engaging in affirmative lobbying and rulemaking activities. However, even with the restrictions, 95% of the cases that could be brought before the 1996 restrictions could still be done.
When major funding has been threatened, it has been the legal community, in particular the lawyers, who have been the ones who have stood up and made the difference. They have been the loudest spokespeople.
Legal Services Corporation did remain funded, but the funding was dramatically cut, and a whole set of restrictions were put in place on what could be done with federal money for civil legal aid.
Clint Lyons served as acting president of the Legal Services Corporation early in the Reagan years and went on to become executive director of the National Legal Aid and Defenders Association. In an interview during the mid-1990s funding controversy, Lyons remembered the impact of the war on poverty. There were times when we did spend a lot of money on reducing poverty. But if you look at the figures, during the time that money was spent, people actually tended to rise out of poverty. Statistics show that, and with the help of legal services programs, this country laid the foundation for a lot of people to escape poverty, to move into jobs.
Federal funding for the Legal Services Corporation amounts to less than what Americans spend every year on Halloween costumes for their pets. Don't tell me we can't afford it. You know what we can't afford? We can't afford to tolerate the continued degradation of justice to the detriment of the disadvantaged. We can't afford to default on the vision of our founders and on the foundational and foremost of their values. That's what we can't afford.
As federal funding began to come into the system for civil legal aid, many of us thought, oh, this is the answer. We're going to see the federal investment go up. But by the mid-90s, we were pretty clear that that was not going to be the only solution. Politically, it wasn't going to happen. And importantly, the federal government is in some ways a fairly small player in civil legal problems. State justice systems are really where the action is.
At least 75% of the people who are financially eligible and desperately need legal assistance do not have access to a lawyer.
We just do not have the resources to provide a lawyer for everyone who needs one. But there are lots of different ways that you can address the legal needs and improve the system so that it can offer justice in creative ways.
One important innovation in funding was introduced first in Florida and other states in the early 1980s. It's called IOLTA, Interest on Lawyer Trust Accounts. Lawyers must hold clients' funds in separate trust accounts. Under IOLTA, lawyers pool the client funds into common accounts whose interest funds legal services for the poor. Every state now has such a program. In California, for instance, more than $20 million per year goes to legal aid through IOLTA. IOLTA became a key part of a trend to expand the sources of funding for legal aid. A more recent innovation came in the Obama administration from federal agencies through a White House program, the Legal Aid Interagency Roundtable. The approach empowered government entities to coordinate their services around legal aid models, increasing the effectiveness of their funding.
Our work with LAIR was really focused on good government. Access to justice was an important byproduct, but the goal was accomplishing policy priorities like stopping domestic violence and helping people with criminal records get jobs.
Today, we see a much more diversified system. We see about a third of the money coming from the federal government. We see another now more than a third of the money coming from state. And then we see a range of other contributors to the system, private foundations and individuals, all servicing a group of some 700 or 800 legal aid organizations that serve everywhere in the nation. Today we have strong bipartisan support for civil legal aid. So just in the last 2 years, we've had another call to eliminate funding for legal aid, and yet that has not happened. And that's because there is, I think, such strong bipartisan support for a certain level of funding, but that is not the entire solution to the problem.
The movement at the state level to innovate and diversify help with legal problems is no accident. One example is the creation, beginning in the 1990s, of state access to justice commissions.
The problems of the lack of access, the problems of the civil justice system not working, that's not just a lawyer's issue or a judge's issue, it's truly a societal issue. We started out with 3 access commissions in the 90s, and now we have at least 40, and that's been phenomenal growth. We basically have dozens of laboratories around the country that are looking at different ways to solve the justice gap.
Access to justice commissions are organized differently in each state, with commissions to include judges and a leadership from the local bar, but also stakeholders across the broader community.
Not only have we had representatives from all over our state and the judiciary, which is extremely important, but we have lawyers who are part of the legal services community, and we have board representatives from the various organizations, and we have an open commitment by our state bar to increase access to justice.
Over the years, we've seen that kind of concentrating our efforts on building these partnerships, building these cross-sector collaborations, placing lawyers in kind of trusted community centers has really changed the way that people view legal aid. We're not looking at it as a last resort, but we actually are looking at it as a solution.
Local leadership breeds local innovation. Massachusetts developed a fellowship program for retired law partners or retiring judges, resulting in more than 80,000 hours in assisting poor clients. The chief judge of the state of New York was instrumental in obtaining an additional $100 million in funding for legal services. The Texas Commission worked with the State Bar and the IOLTA Commission to raise legal funding to $25 million in the state. Washington, D.C., Louisiana, and North Carolina launched initiatives supporting pro bono work. The local emphasis of access to justice commissions allows the group to focus on key problems facing the community. In California, for instance, the Justice Commission developed a system for helping low-income clients facing evictions.
And so in response to that, these groups came together and formed a clinic which was designed only to do those papers, so that the tenants could come in and get their paperwork done, and then our organizations could do what we do best, find legal aid lawyers or find pro bono attorneys to represent those tenants and help them get through the rest of the eviction case.
In eviction cases in New York City, Los Angeles, and San Francisco, tenants are referred to lawyers who are paid with public funds. The result is a reduction in homelessness, but also burdens on courts are reduced because trained lawyers recognize flawed cases earlier and reach settlements. In Los Angeles, for example, providing more lawyers has lowered the number of jury trials and reduced the burden on the court. Some of the biggest challenges for access to justice comes down to location. In rural California, the small number of local lawyers cannot fulfill the legal needs of migrant farm workers and other low-income people in the area. The Justice Bus Project takes teams of attorneys and law student volunteers, loads them onto an actual bus, trains them, and then travels with them out to rural communities. Once they're on the ground, they work together with a local legal nonprofit, and they set up and staff free legal clinics. Our nation's long journey toward equal civil justice depends on the commitment of many people: attorneys and judges, activists and civic leaders, citizens of all stripes. The victories in this long struggle are seen in small but profound transformations. A burden is eased, a life is changed, a person is given hope.
People who have resources get the lawyers they need. People without them are dependent on legal aid and willing lawyers to represent them at the most critical times of their lives, facing a divorce, domestic violence, facing eviction from their homes, not being able to get health care for themselves or their children. No time is their lives at greater stake in their needs than when they come to a legal aid office. I have never had a client call me and say, I just wanted you to know everything's fine, I don't have any problems right now. They call when they are in legal crisis.
Working with clients is one of the best parts about being a legal aid attorney. When I first started, there was the saying that we'd be giving a voice to the voiceless, because the situations that they face just really invoke a passion in me. They've faced so much hardship. And so getting to know them, getting to know their struggles makes you a better legal services advocate. The best part about resolving a lawsuit, I think, is when a client calls you to say thank you. And you see that sort of glimmer of hope in their eye, that little bit of confidence that they know that justice can prevail and that wrongs can be made right.